Prenuptial agreement in family law is normally termed a binding financial agreement. Prenuptial agreement means that prior to entering into any relationship that's going to be a continuing relationship, or it's going to be or a marriage, people may consider that they want their rights and obligations and their rights to their property clearly defined in an agreement. So if at any time after the relationship breaks down, they want to know that their assets are protected. Prenuptial agreements are before entering into a relationship or a marriage. A financial agreement can take place before a marriage and has effect after the marriage has taken place, or after a divorce of a marriage, or after the breakdown of any relationship. Prenuptial agreements are, under the legislation, the Family Law Act, very complicated agreements. There are many rules and obligations that have to be dealt with if that agreement is going to be binding. If it is not dealt with properly, then the agreement will be set aside by the court. The courts are very concerned about people entering into a prenuptial agreement because the agreement takes away the rights of those people from the Family Law Act. The prenuptial agreement requires a very detailed advice to be provided, and it is advisable and almost an obligation to have those detailed advices set out in writing, so that if there is a breakdown in the relationship, then the advice given is clearly set out in that written advice. And if a proper advice is not provided by a lawyer, and it is a lawyer that is required to draw up these agreements and to sign a certificate that they have given the advice, if that advice is not properly provided, then the agreement will be set aside. Prenuptial agreements or financial agreements are a means of making sure that your rights are protected when entering into a relationship or a marriage. You must obtain legal advice in regard to those documents, and as stated, if the advice is not given, then the courts will set those agreements aside.